The room was supposed to be quiet, a routine oversight hearing. 5 hours of procedural questioning, bureaucratic answers, and the kind of congressional theater that usually disappears from the news cycle by midnight. That was the plan. That was what everyone expected when Pam Bondi sat down in front of the House Judiciary Committee on a February morning in 2026. And for the first few hours, that is exactly what it was. Lawmakers asked questions, Bondi deflected. Staff members shuffled papers, cameras rolled without much reason to zoom in. Then Jasmine Crockett picked up the microphone, and the room changed. Not because she shouted, not because she threw documents across the table or lost her composure. She did none of those things. What she did was quieter, more deliberate, and in the long run, far more consequential than anything a shouting match could have produced. She walked into that hearing room with a strategy. She knew exactly what she was going to say, exactly which documents she was going to reference, and exactly what Bondi's response options were before Bondi had spoken a single word. This was not a spontaneous eruption. This was a calculated legal and political demolition, executed in front of cameras, entered permanently into the congressional record. And when it was over, the most powerful law enforcement official in the United States had been placed in a position where every answer she gave only deepened the problem. Here is what actually happened. And here is why it matters far beyond one heated exchange. Let's go back to where this actually started. Because the confrontation between Crockett and Bondi did not emerge from nowhere. It was the product of years of accumulated institutional failures, broken promises, and a documentary record that kept growing even as official explanations kept shrinking. Jeffrey Epstein died in federal custody in August 2019. The official ruling was suicide. The skepticism was immediate, and it has never gone away. For years, the public was told that the full scope of Epstein's trafficking network, the names, the dates, the documented connections to powerful figures, would eventually be released. It was promised by multiple administrations. It was demanded by both parties in Congress. It was the subject of legislation, lawsuits, and endless public pressure. Pam Bondi became Attorney General under the second Trump administration. And when she arrived at the Department of Justice, she made a very specific and very public commitment: full transparency on the Epstein files. She distributed binders to conservative influencers at the White House. She stood in front of cameras and used the word transparency so many times it started to sound like a legal term rather than a policy position. The promise was clear. The files would come out. The public would see everything. The cover, whatever it was, would be lifted. Then the files started coming. And something was wrong. The redactions were not random. They were not uniformly applied. Personal identifying information belonging to Epstein's victims, information that should have been protected above almost anything else, appeared in released documents. Names, identifying details. Vulnerable survivors of one of the most documented trafficking operations in modern American history, exposed in the release that was supposed to bring them justice. Meanwhile, the names of powerful men connected to Epstein's network remained hidden. The redactions were not protecting the vulnerable. The redactions were protecting the powerful. And that inversion, that reversal of exactly who deserved protection and who received it, is what Jasmine Crockett walked into that hearing room prepared to confront. When she picked up the microphone, she did not start with a question. This is important. It was a strategic choice. She started with a number: 38,000. That was the figure she placed in front of Pam Bondi and every camera in that room. At least 5,000 files, she said, containing more than 38,000 references to Donald Trump, his wife, or Mar-a-Lago. 38,000 references, not 10, not 100, 38,000 documented appearances of those names in the files of a convicted sex trafficker and the network he operated. Crockett was careful to state explicitly and on the record that she was not asserting the president had committed a crime. She framed her remarks as oversight, as the kind of scrutiny any functioning justice system must apply when a sitting president's name appears that many times in the files of someone who ran a child sex trafficking operation. She said clearly, this is grounded in the public record. She said clearly, if this were anyone else, we would not be having this conversation. The investigation would already be done. The room got quiet in the way rooms only get quiet when something genuinely heavy has just been said. Bondi sat at the table. Her expression did not change, but the legal team around her shifted. You could see it in the body language, the slight lean forward, the whispered exchange, the preparation for whatever was about to come next. Crockett continued reading. From the documented record, from materials connected to Epstein's trafficking operation. She referenced the claim, sourced to documents in the files, that Epstein and Ghislaine Maxwell made young women available to Trump on multiple occasions. Again, she was precise. She was not making a criminal allegation. She was conducting oversight. She was asking the chief law enforcement officer of the United States to explain why these specific sections of these specific files remained partially sealed, while the names of billionaires and power brokers connected to the same network stayed hidden inside redacted pages. And then she asked the question that no one had a clean answer to. Which ongoing investigation, she wanted to know, specifically requires these particular documents to remain classified? Which active case, which open prosecution, which pending legal matter justifies keeping these materials from the public? Bondi leaned toward the microphone. She said she could not discuss potential investigations in open session. She said reclassification reviews were standard interagency procedures. She said the Department of Justice was committed to transparency while also managing sensitive materials that required careful review. Crockett did not immediately respond with an argument. She paused. She let the contrast between what Bondi had promised and what Bondi had just said sit in the room. Transparency, she pointed out, does not typically mean an 18-month delay. Protecting sensitive materials does not typically mean redacting the names of wealthy men while publishing the personal details of their victims. And the midnight Friday filing requesting additional time was not, she suggested, a standard legal precaution. It was a pattern. Bondi's defenders would later argue that reclassification reviews are genuinely complex, that national security considerations cannot always be explained in open session, that the Department of Justice cannot conduct investigations in the court of public opinion. These are not absurd arguments. They reflect real procedural constraints that apply in any sensitive federal investigation. But here is the problem. These arguments only work if you accept that the redaction decisions were made for legitimate investigative reasons and not for the protection of individuals connected to the current administration. And the record, the actual documentary record that Crockett was reading from, made that acceptance difficult. Because the redactions were not symmetric, that is the core issue. A truly neutral process protecting truly sensitive investigative information would redact names consistently based on their role in an investigation, not based on how much power those names currently hold. The pattern in these files did not look neutral. It looked selective. And selective justice is, by definition, not justice. Crockett moved through other cases. The killings of Renee Good and Alex Preddy in Minneapolis, federal investigation requests that had stalled, the FBI's seizure of 2020 election ballots from Fulton County, Georgia. She was building something larger than one argument about one set of files. She was constructing a portrait of an institution under political management, a Department of Justice that made decisions based not on the weight of evidence, but on the proximity of the people involved to the people in power. And then she delivered the line that has been quoted and replayed more than anything else from that day. She said Bondi would be remembered as one of the worst attorneys general in American history. Not because of incompetence, but because of something she called a choice. The choice to prioritize loyalty over law. To protect the powerful while the vulnerable waited. To stand in front of cameras with binders and make promises that the documentary record showed she either could not keep or had not tried hard enough to keep. She yielded the rest of her time. She handed the microphone back without asking a question. And that choice, that deliberate decision to make a statement and then step away from the table, was itself a message. She was not there for a debate. She was there to build a record. And the record was built, Bondi responded. And her response revealed the pressure she was under even in the way it began. She accused Crockett of not asking a single question. This was technically accurate. Crockett had made statements and cited documents rather than posing questions in the traditional hearing format. Bondi used this to frame the exchange as political theater rather than legitimate oversight. She was not wrong that Crockett's performance was calculated for maximum political impact, but the framing of it as theater rather than substance required ignoring the substance of what had been said. The numbers Crockett cited were real. The documents she referenced were real. The pattern she described in the redactions was real and had been independently noted by Republican committee members as well. Then Bondi reached for a counterattack. She mentioned Hakeem Jeffries. The Democratic House Minority Leader, she suggested, had financial connections to Epstein-linked sources after Epstein's conviction. Jeffries denied the claim. But Bondi had placed the name in the room, in the record, at a moment when she needed to shift attention away from the specific and documented questions that had just been posed. This is a recognizable legal and political maneuver. When the argument on the merits is difficult, you expand the frame. You make the opponent defend a different position. You change the subject in a way that sounds like a direct response. And then came the photographs. Bondi held up images of individuals she identified as foreign nationals convicted of serious crimes in Texas. She read their offenses: homicide, kidnapping, rape. She looked toward the space where Crockett had been standing and said this was what was actually happening in her state. This was what the Justice Department was focused on. This was what Democrats were trying to distract from by keeping the conversation on Epstein. Crockett was already on her feet. She said one word as Bondi was reading: convicted. These people had been prosecuted. The system had worked for them. Then she said what was already on the record. She pointed toward the women seated behind Bondi. The survivors, the people who had been in that room for 5 hours waiting for someone to explain to them why the names of the men who had trafficked them were still hidden. She asked whether those crimes had been prosecuted, whether those perpetrators had been convicted, whether justice for those specific victims sitting in that specific room had moved at the same speed as justice for crimes Bondi was now using as a rhetorical device. Bondi finished reading her list. Crockett walked out of the hearing room, and that exit has been misread by almost everyone who has covered this story since. She did not walk out because she lost the argument. She walked out because she had finished what she came to do. The record was in the transcript. The numbers were on the page. The questions that Bondi had answered by not answering them were now permanently attached to the official congressional record of an oversight hearing. Crockett knew, as any experienced litigator knows, that the most dangerous thing you can do in a proceeding where you hold the evidentiary advantage is keep talking. She said what needed to be said, she documented what needed to be documented, and she left. What happened in the room after she left matters less than what remains in the record after she left, because here is the legal reality that almost no coverage has properly addressed. Congressional hearings are not courts. They do not produce verdicts. They do not compel prosecutions. A witness at a congressional hearing cannot be held in contempt for an incomplete answer the way a witness under oath in a federal proceeding can be challenged. But congressional records feed into other processes. They become reference points for future litigation. They establish on the public record what questions were asked and what answers were given or not given. And when an Attorney General of the United States sits before Congress and is asked a specific documentary question about why specific names remain redacted in specific files and responds by saying she cannot discuss potential investigations in open session, that response enters the record. Every future proceeding that touches these same documents will carry that answer as context. There is something else in this record that has not received enough attention. Republican committee member Thomas Massie sat in the same hearing and questioned Bondi about a specific document in which a billionaire's name had been redacted. He identified it, he pressed. The Department of Justice unredacted the name, Massie noted, within 40 minutes of him catching it, and then he used a phrase that should not be forgotten. He said, 40 minutes of me catching you red-handed. A Republican, in the same hearing, using language that aligned structurally, if not politically, with the argument Crockett was making from the other side of the aisle. This is not a partisan story dressed up as a legal one. This is a legal story that happens to have partisan actors on both sides. The question of whether the Epstein file redactions were made for legitimate law enforcement reasons or for the protection of politically connected individuals is a question that both parties have now raised in the same room on the same day. That convergence is significant. It does not resolve the question, but it does remove the ability of either party to dismiss it as purely political. The survivors who sat in that room know this better than anyone. One of them, Danielle Bensky, who first encountered Epstein's network in 2004 when she was 17 years old, was present when Pramila Jayapal asked the victims to raise their hands if they had not been able to meet with a member of the Department of Justice. Every hand in that row went up. Bondi had issued an apology at the beginning of the hearing. She had called Epstein a monster. She had said she was deeply sorry for what victims had endured, but she had not turned to face them when asked to do so directly. She called that request theatrics. That characterization is now in the record as well. Here is where things actually stand and why the next 60 days matter in ways the coverage has not fully captured. The appeals processes connected to Epstein-related litigation are moving on their own schedule. The pressure to release additional materials is not coming exclusively from Democrats. It is coming from across the political spectrum, from journalists, from legal advocates, from the survivors themselves whose civil cases are still active and who have the right to access information relevant to their claims. The Department of Justice's position that certain sections must remain classified is sustainable only as long as no specific legal challenge successfully proves that the classification was applied improperly. And those challenges are being prepared. record. Bondi sits in the middle of all of this, carrying a promise she made publicly and a record that documents how incompletely that promise has been kept. Every future hearing, every future filing, every future ruling that touches these files will carry the shadow of that gap. And Crockett's documented reading of those numbers, 38,000 references and 5,000 files, is now the reference point that anyone building that case will return to first. This is not finished. This is not even close to finished. What happened in that hearing room was a layer being added to a foundation that keeps getting deeper. The confrontation that went viral was real, the political theater was real, but underneath the theater there is a documentary record that moves at its own pace and does not care about news cycles. The transcript exists, the numbers are in it, the questions that went unanswered are in it. The moment when the survivors raised their hands is in it, and the Attorney General's decision not to turn and face them is in it. Records do not disappear, and this one is just getting started. Stay close. Because the next filing, the next ruling, the next time someone in that building picks up a document and reads a number out loud, you will need to have seen this first. The story is not over. It has barely begun.